to happen.
So say that again, since you kind of mixed it up.
What did I mix up?
Take care of who?
He asked if there was anything Shanna wanted him to take care of, and she said Jared, and then she said absolutely not.
Okay, so who said Jared?
Shanna.
Okay, so I want to break down. Mario Fernandez says, is there anything you want me to do to take care of?
Correct.
And then she said Jared.
Yes.
And then Mario said okay.
Mario didn't say anything. She said no.
And then she said no.
She said absolutely not is what she said.
And this is what Shanna Gardner is relating to. Because it would exist. We do have third-degree child abuses with an act that could intentionally lead to mental injury to a child. Those exist.
Quote me a case.
I don't have a case right off the top of my head. It's the statute. About was the 10 millimeter.
I told him that?
Yes.
I don't remember saying that, no, sir.
And do you remember saying that it had been in your possession the entire time?
I don't recall saying that. Actually, I think that was one of the first things said after I saw that he was pressuring me for more information.
Okay, so now you remember saying that the 10 millimeter has been in your possession the entire time.
I may have said that, yes, sir.
Was that the truth or a lie?
That would have been a lie.
To your law enforcement son?
That's correct.
Do you remember discussing that you felt law enforcement was concerned because of your relationship with Mario Fernandez? Do you remember that discussion?
No.
So the first thing you said is you've had it the whole time, but then do you explain to the jury what you remember about the second conversation where you said it was going to appear at the turn of the year?
I never said that in the beginning. In the beginning, I told him I didn't know where they were.
Okay. And then you said you had it the whole time. And then you said it was...
Somewhere during the conversation, I told him that I'd had them. Then I told him that somebody else had them, and that they could produce them by January 1st.
Okay, so those are the three things. First, you said you didn't know. I'm leading just to try to make it quick. Second, you said that you've had it the whole time. And then third, you said it's...
And I want to ask you a question that the government didn't ask you. And if you don't understand my question, you tell me, because I'm going to try to make it as simple as possible.
Okay.
Did you ever give Mr. Fernandez a 10 millimeter firearm?
No, sir.
Did you ever give Mr. Fernandez any firearms?
Never. No, sir.
Did you participate in the planning of the murder of Jared Bridegan?
No, sir.
Did you help Mr. Fernandez in any way?
No, sir.
Did Mr. Fernandez ever tell you he participated in the murder of Jared Bridegan?
No, sir.
Did Mr. Fernandez ever admit to you that he had anything to do with the death of Jared Bridegan?
No, sir.
Which is a .40 caliber, and ammo and other police paraphernalia.
When you provided the serial numbers for those firearms, did you make an error?
Yes.
Tell the jury about it.
So when I was waiting for Dallas police, I referred back to that inventory and just unintentionally copied down the incorrect serial number, which happened to be for the Glock 10 millimeter, not the Glock 27.
I understand those are on lines 7 and 8?
I believe so, yes.
I'll approach just to make sure. State's Exhibit 190. Counsel is correct. It's the Glock 27 is line 6, and then the Glock 40 10 millimeter is line 7.
Yeah, correct, yes.
Now, you would agree that this State's 190 is lined,
Yes,
and you filled it out.
yes.
when you reported the 2 firearms that were stolen, you were aware, or were you aware, I guess is the better question, that the 10 millimeter firearm was important to police?
Yes.
Because you had actually worn an undercover recording device to talk to your father about that 10 millimeter.
Right.
And you, based on your training experience, are stolen guns and reporting them accurately important.
Yes, sir.
You would agree that you did not report it accurately.
Correct.
And the serial number that you put down was to a firearm that you knew police were very interested in locating.
Yes.
Stolen.
Yes.
At some point, you came back to Jacksonville and you were interviewed or met with the state attorney's office again. Is that correct?
Yes.
And during that subsequent meeting, it had become clear to you that law enforcement did not believe your position on the 10 millimeter, correct?
Correct.
Someone had actually filed some sort of a complaint with your agency that they didn't believe you were being truthful.
Correct.
Ultimately, they put you on administrative duties as a result.
Yes.
No one actually found that you were being untruthful, but because of that complaint, they placed you on administrative duties.
Yes.
You understood that the people sitting at this table, Ms. Stifler and Mr. Mizrahi, didn't believe you.
Correct.
They said as much.
Yes.
And during one of those meetings, they actually offered you immunity in the event you wanted to tell a different story.
Yes.
Did you accept that immunity?
No.
And you know what immunity is from your law enforcement experience, correct?
Yes.
And whether or not that included federal authorities sitting in the room or otherwise, you were interviewed by ATF multiple times
Yes.
and by state law enforcement.
Yes.
Do you stand by every statement you've given to them?
Yes, I do.
You told the truth every time.
Yes.
Certainly don't want to have a negative impact on your new family by being untruthful with them.
Correct.
Mr. Bickerstaff, did you have any involvement in the homicide of Jared Bridegan?
No.
Do you have any reason, do you have any evidence that Mr. Fernandez had any involvement in that homicide?
No, I do not.
Do you have any involvement with disposing of a firearm?
No.
Now on page 60, what is that?
That is a check written to Mr. Tenon for $2,000 from First Choice Home Rentals, LLC, on March 28th, 2022.
And for how much?
$2,000.
And for what?
According to the memo line, it's for landscaping and clearing.
The person that writes the check puts that information on.
Yes, sir.
In reviewing the records of this case, did you find any invoices from Henry Tenon charging for $2,000 worth of landscaping and clearing?
No, sir, I did not.
And who signed the check?
Mario Fernandez.
And then on the same day, there's another check on page 62. Please read it for the record.
Also from First Choice Home Rentals, LLC, to Mr. Tenon for $3,000. It says keeping up with the roof, also signed by Mario Fernandez.
Again, did you see any invoices corresponding to that?
No, sir.
And is that the deposit slip for the $3,000 on page 63?
Yes, sir, that's correct.
Then the next check is 4/4 of 2022 on page 64. What are we looking at here?
Also, the third check written by First Choice Home Rentals, LLC, dated 4/4/2022, made out to Henry Tenon for $5,000. The memo line says Kickstarter, good luck, and it's signed by Mario Fernandez.
So for the period of time that you looked at Henry Tenon's bank records, were these payments different from the payments?
He had plenty of money in his own personal checking account, right?
Yes, that would have come from the trust.
We just talked about that on 12/28, he deposited $75,000 from the gardeners, right?
Yes,
That didn't come from the trust. Did it?
Overall, I'm saying the amount of money that he was only making $37,000 a year.
We have to be really careful with our words.
I agree.
Money goes from the trust account to, and I'm going to walk you through it. We're not going to guess, trust me. We're going to go through every single trust account record to see where that money went. But I'm asking you a very basic financial question. You can transfer money from the Shanna Gardner Trust to Mr. Fernandez. He could do that if he wanted to, correct?
Yes, he was the trustee.
That did not happen. That $50,000 did not come from the trust account, did it?
No, that specific transaction came from his account.
Right. And let's say on December 28th, Mr. Fernandez got $75,000. That could have come from the irrevocable trust, hypothetically, right?
Yes.
But it didn't. And this is why I want to make sure that words matter. Shanna Gardner's parents, Shelley and Sterling Gardner, wrote him a check for $75,000 at the end of the year, right?
Yes.
That's where that money came from.
The assets are commingled.
They're not.
They wrote him a $75,000 check, and he did transfer $50,000 from his account.
Okay. We're really going to figure this out together. The Gardners live in Utah, right?
Yes.
And they're private wealth clients of Chase Bank, correct?
Yes.
Because you know that because it says it right on the check. $75,000. This is an example of the two checks that the Gardners gave them, right?
Yes, sir.
You're saying it was commingled, it all came from the same place. This came from a checkbook as a Chase private client from Shelley and Sterling Gardner, right?
Yes, sir.
From their bank account, right?
Yes, sir.
That did not come from the irrevocable trust, correct?
No, that check was, the check that you just showed me was deposited into the trust.
Right. And the identical check, with the exception of it saying Shanna Gardner, it said Mario Fernandez, right?
Yes.
And that came from the Chase private wealth management banking account of Sterling and Shelley Gardner, right?
Yes, sir.
So that didn't come from the irrevocable trust, right?
That specific $75,000, no, it did not.
Okay. And in addition to all the other money that Mr. Fernandez had, you're saying, well, it's all commingled. It came from the irrevocable trust. Isn't that what you're trying to say?
Yes.
Well, $35,000 of it came from Mercedes-Benz of Jacksonville when he sold his Tesla, right?
Yes.
That didn't come from the Shanna Gardner irrevocable trust, did it?
I mean, you'd have to go back and look and see. You'd have to have a much larger picture of knowing where the Tesla was purchased from.
The check came from Mercedes-Benz of Jacksonville, right?
For an asset that was sold to them, but we don't know how that was purchased.
You don't know. So you can't say it came from the Gardner irrevocable trust, can you?
You're correct, I can't.
Right. Because you know for sure it came from Mercedes-Benz of Jacksonville, right?
Yes.
So let's talk about two things that we know for sure. $75,000 came from the Gardners personally, not the trust account, right?
That's correct.
And $35,000 came from Mercedes-Benz, right?
Yes.
So that's $110,000 right there that we know for a fact did not come from the Gardner Trust, right?
It would depend on how the Tesla was purchased.
Show the jury, please, if Mr. Fernandez got one single penny from the irrevocable trust.
There is a $1,500 transfer. There again, the statement does not indicate what checking account it was transferred into.
Okay. So if he did get a penny, it's $1,500, and you agree as you sit here, you have no idea whether he got it or anybody else in the world got it.
The statement doesn't state what checking account it was transferred into.
Okay. But you have all of Mr. Fernandez's checking accounts for that exact same time period, right?
Yes, I do.
So you would be able to find out in 2 seconds if that went to Mr. Fernandez, couldn't you?
Yes.
that Mr. Fernandez paid Mr. Tenon in November of 2021?
I'm sorry, can you repeat the question?
What evidence of payments do you have that Mr. Fernandez paid Mr. Tenon any money in November of 2021?
There were statements made that indicated that one of them was a payment.
You have 3 payments in March, 2 payments in March and 1 in April. I'm asking you of November of 2021.
There was no payments made that I'm aware of.
No payments from Mr. Fernandez to Mr. Tenon in November of 2021. Will you agree with me?
Yes,
There are no payments that you have any evidence of between Mr. Fernandez to Mr. Tenon in December of 2021, correct?
unless there was some cash exchange, there's no evidence of that.
You don't have evidence that the cash was exchanged, do you?
No.
What evidence, and you have no evidence, that any financial transactions occurred between Mr. Fernandez and Mr. Tenon in January of 2022, correct?
That's correct.
Okay. So that's the 3 months preceding the homicide, right?
Yes.
And then there's 16 days in the month of February. You have no evidence that Mr. Fernandez paid Mr. Tenon one single nickel in the 16 days preceding the homicide, do you?
Correct.
Okay. So far, you've agreed with me that Mr. Fernandez hasn't paid Mr. Tenon one single penny prior to the homicide, correct?
Unless it was a cash payment. That's correct.
All right, everyone may be seated. Please let the record reflect that the jury's left the courtroom. Mr. Dreiser.
Your Honor.
Oh, Mr. Hill, sorry.
Good afternoon. Your Honor, on behalf of Mr. Fernandez, number one, we would renew all previously filed motions with no additional argument to those motions, but this time we would be making motions to count 1 and count 2 for a judgment of acquittal. And if I may, I'll take a few minutes with these. As the court is well aware, judgment of acquittal is pursuant to Rule 3.380. If the close of the evidence for the state or at the close of all evidence in the case, the court is of the opinion that the evidence is insufficient to warrant a conviction, it may, on the motion of the prosecution or the defendant, enter a judgment of acquittal. And as the the court is well aware, that standard changed in 2020 pursuant to Bush v. State 295, Southern 3rd, 179, out of the Florida Supreme Court. Whether the state presented competent, substantial evidence from which a rational trier of fact could find the existence of the elements of the crime beyond a reasonable doubt, viewing the evidence in the light most favorable to the state. So I want to start with count 2, the solicitation, Your Honor. The state is required to prove the defendant commanded, encouraged, hired, or requested another person, in this case, Henry Tenon, specifically from November 1st of 2021 to February 16th of 2022, requested Henry Tenon with the present intent that the other person actually carry out the offense. As the state has in their case, it's not necessary for the defendant, Mr. Fernandez, to do anything in furtherance of the offense. However, to solicit means to ask earnestly or to induce another person to engage in that contact. So the definition of earnestly means a serious manner, not lightly, casually, or flippantly. The statute requires, there is no affirmative defense that we have alleged. However, it does require an affirmative communicative act, a command, encouragement, hiring, or request directed at another person. I would point out that the state has not submitted any evidence to the jury of that affirmative communicative act. There's been no testimony that Mr. Fernandez has said a word of encouragement, a text message, an email, or any other act that would actually support that he solicited Henry Tenon. And I'd point to several different cases that specifically are on point, which is in order to show the present intent, and that would be the Florida Bar versus Marable, 645 Southern 2nd, 438.
Slow down. 645 Southern 2nd.
Yep, and I'm going to email those cases to you at this moment, Your Honor, as well as to the state. in that sense, so you'll have electronic copy of all case law. Bear with me, Your Honor, I'll give you that exact citation. That was 645 Southern 2nd 438, 1994. And it was Marable, M-A-R-A-B-L-E, which establishes that present intent is required, meaning that Mr. Fernandez would have to have the present intent in addition to the solicitation and the communicative act in order to be found guilty and sustain a conviction for solicitation to commit a capital felony. In addition, Palumco, P-U-M-B-L-A-N-C-O, v. State, which is 111 Southern 3rd, 249 out of the 5th DCA, and that was 2013. In addition, State v. Gaines, 431 Southern 2nd, 736, 4th DCA, 1983. That actually established what's considered the Gaines standard. In order to support, there has to be a present intent. In that case, a particular person, their conviction was overturned when they expressed a desire for this to happen in the future, but they did not actually formalize that solicitation. And the court found that that person did not have the present intent for the crime to actually have occurred. Additionally, Your Honor, Jones v. State, 908 Southern 2nd, 615 out of the 4th DCA, which is 2005, requires guilty knowledge or mens rea on behalf of the defendant. I would just point out that there's been no witness who has testified, number one, of any evidence of the actual earnestly requested solicitation by Mr. Fernandez to Henry Tenon during the time period alleged, and simply having that relationship in and of itself with Mr. Tenon is found to be insufficient to sustain that conviction. There's no evidence of encouragement. There's no evidence that Mario Fernandez hired Henry Tenon to commit this homicide. Even in the light most favorable to the state, the checks that have been presented by way of Detective Johns and Miss Lindsay Butler are post the time period of which the state has charged Mr. Fernandez. There's been no testimony that those were actually for the homicide. There's been evidence submitted that Mr. Tenon completed legitimate work by way of the recorded phone call and the poll cameras that are in evidence as well. Additionally, with regards to count 1, as a principle, murder in the first degree, there again has been no evidence of the intent. There has to be a communicative act to show that Mr. Fernandez had an intent for this crime to occur. Having a not positive relationship, if the state were to rely on the interview of Mr. Fernandez, where he clearly states that him and Mr. Bridegan didn't have the best relationship, that in and of itself is not sufficient evidence to submit to the jury that Mr. Fernandez had the intent that Jared Bridegan be murdered. Additionally, the second element, as a principle, that the defendant did some act or said something, again, a communicative act, or did some act that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. There has been no evidence at all to establish Mr. Fernandez's intent. Nothing to be submitted to this jury, either for the solicitation or for the murder in first degree as a principle. As the state conceded, Henry Tenon is who they believe to have actually committed the homicide, not Mr. Fernandez. That is why they have submitted the principal instruction. Again, simply having that relationship with Mr. Tenon does not carry the day. With regards to element 2, we have heard no evidence of any incitement, cause, encourage, assist, or advise the other person to actually commit the crime. And I would draw the court's attention to a case that's so close to being on point. It's in essence a man killing the husband of the woman he was having an affair, and that's Williams v. State, 314 Southern 3rd, 775. That is a first DCA case from 2021. That proof of a relationship alone with the perpetrator is not enough. There must be proof of some overt act or words uttered in furtherance of the scheme that led to the murder, and where no such evidence exists, a motion for judgment of acquittal must be granted. Under Penny v. State, which is 421 Southern 3rd, 476, out of the 2nd DCA of 2025, in order to be a principal in a crime, one must have a conscious intent that the crime be done and do some act or say some word which was intended to and does incite, cause, encourage, assist, or advise another person to actually commit the crime. The one other point I would establish is that v. Coxwell v. State, 397 Southern 2nd, 335, 1981, establishes that both the principle for first-degree murder and solicitation both require the same communicative act in order to establish the intent, as well as with count 2, the actual solicitation. This means that solicitation charges and the principal liability charge both require the same proof of the communicative act, the act of counsel, procurement, or instigation. Where the state has submitted no evidence of that act, both charges fail simultaneously. The absence of any evidence of the communicative act, therefore, is fatal to both the solicitation charge as well as the principal liability charge. There's been no evidence submitted. I would argue contrary evidence that Mr. Fernandez had any motive to commit this crime, much less any intent that was submitted into evidence. There has been no testimony whatsoever to establish the intent element, certainly no evidence of communications that support the intent or an overt act. And mere association with or proximity to the perpetrator is insufficient to establish principle. Applies to both murder as well as, by principle and solicitation. In every Florida case, a solicitation conviction has been sustained. There has been some.
I believe that the evidence that this court has seen through the testimony of the witnesses, viewed in the light most favorable to the non-moving party, which is the state, is sufficient to go forward. So I'll deny the motion for judgment of acquittal.
Was that to both
On both
counts?
counts. On both counts.
Understood.